January 8, 2022, the story was updated with a statement from the National Safety Council. There is a lot riding on the outcome of the U.S. Supreme Court's decision whether to allow the implementation of President Joe Biden's vaccination mandates for employers with more than 100 workers. The court heard 2 hours of oral arguments about the legality of the requirements on Friday. The employer mandates would impact more than 80 million employees, or about 2/3 of the U.S. workforce. If the court allows the requirements to be implemented, the employers will need to. National employment litigator David Gordon with Mitchell Silberberg Knupp said that, by January 10, large employers must have a plan in place to address the OSHA rule, and they must also have identified who is unvaccinated. For now, employers must assume as if, on Monday, they will be subject to these requirements. Likewise, unless the court grants a brief stay while it decides the broader issues, all unvaccinated employees, as of Monday, must be masked while at work. There was no indication when the court would issue a ruling. Lorraine Martin, President and CEO of the National Safety Council, said in a statement that, COVID-19 is the greatest workplace safety challenge in generations. The way we see it, employers shouldn't wait on the courts to tell them what to do. They should implement these mandates, because that's the best way to keep workers safe and businesses operational. Opponents of the mandates told the court they would cost businesses billions of dollars, impose admin. CNN noted that, critics of the requirements, including a coalition of business groups in Republican-led states, say the Biden administration exceeded its authority in issuing such sweeping mandates. The administration, on the other hand, focuses on the impact of the virus that has already killed some 800,000 Americans, closed businesses and kept children out of classrooms. U.S. Solicitor General Elizabeth Prelogar told the justices that Biden's mandates would save 500 lives and prevent 250,000 hospitalizations in the next 6 months, and that exposure to COVID-19 is the biggest threat to workers in OHSA's history. According to Jeffrey Swartz, a constitutional law professor at Western Michigan University's Cooley Law School, the standard for maintaining or granting a stay is that there is no reasonable likelihood that the government will prevail on the issues at trial. The government was able to provide evidence sufficient to show why they would succeed in court if the case went to trial, and their reasoning was enough to justify why the stay should be lifted. The issues here are far-reaching, relating to actions taken by administrative agencies.